And we are waiting to listen to your presentation. Thank you.
Thank you, too, for the introduction. And I'm Veronica Meneghetti, a lawyer at Roder & Partner. And it's a pleasure for me to be here in Bolzano to speak about one of the most important, fascinating, and complex legal challenges of our time: the ownership and the risk connected with the use of data in training AI system. So let's go to the third part of our discussion: artificial intelligence. Of course, I'm not here to explain you what an artificial intelligence is. You probably know it far better than I do, but let me give you the legal definition of an artificial intelligence. According to AI Act, AI systems means a machine-based system that is designed to operate with varying level of autonomy that maybe exhibit adaptiveness after deployment, and that, for explicit or implicit objectiveness, infer from the input it receives how to generate outputs such as prediction, content, recommendation, or decision that can influence physical or virtual environments. So, what matters today is input. Input that we give to the artificial intelligence to give us an output. For example, an image, a text. And artificial intelligence is magic? No. Artificial intelligence is data-driven. AI is based on data. In fact, we are living a digital transformation that is fundamentally based on data. But despite data are the fuel of the AI revolution, data can create some problem about the legal status of data. And we have some problems that can we reassume with two main questions. So, is it possible to use all data for the AI training? And then the second one is, who is responsible for the use of data in AI training? So, let's go to the first question of our discussion. Can I use all type of data for the AI training? The answer is no. No, because whole data can be protected by intellectual property right. Not all of data can be free for use, even if it's technically accessible online. And behind each data can be intellectual property like dataset and copyrights. And let's focus on dataset. What is a dataset? A dataset is, under European law and Italian law, a protectable work made of individual elements arranged systematically and can be accessible individually. That means that scraping and reusing data can infringe the dataset owner. In particular, if data are taken without the authorization of the data owner. In fact, only the data owner has the exclusive right to use and extract data from dataset. Under copyright law, there are some exceptions. Exceptions provided by Article 3 and Article 4. Article 3 allows the use of data for scientific purpose. So, you can use data for scientific purpose for training AI system. The second case is if the data owner has not opted out the use of data for training AI system, which means that the data owner of the dataset hasn't says you cannot mine my data. In this case, the use of data is lawful. On the other side, if the data owner, the dataset owner has opted out, for example, with technical system like robot text, or with clause in the terms and condition of the dataset, the use of dataset in the training AI system can be unlawful. So AI regulation is going in the same direction of the copyright law, and the AI regulation, in fact, imposes strict obligation to AI providers. In particular, he imposed to comply with the copyright law, so you have to protect the data and all the intellectual property rights. And then you have to implement regulation by design mechanism that ensure the dataset, ensure that the dataset are protected. So it can reassume as build compliant into the innovation, not after it, because there can be some problem. How can we reassume what an AI developer must do? He must check whether an opt-out exists, and if it exists, he has to respect it. Then he has to document compliance. And remind that transparency is the key of the innovation, in particular if your datasets are made of intellectual property rights. And in this context, open data licensing can help to ensure transparency and legally use of data in training AI system. This is because the open data licensing allows AI developers to rely on data that are legally accessible online, and then he can indicate all of the rights and the obligation connected with the use of data. For example, some open data licensing guarantee the possibility to share, create, and adapt, but at the same time, it imposes some obligation. Obligation to attribute the source of the data, to share alike, and then to keep open the data, the dataset. And remind that open is not a synonymous of free, because even if a dataset is open, it cannot free for all. And what an open license guarantee? Guarantee legal clarity connected with IP protection, the ownership and transparency, and then the share alike principles. So let's go to see what can be happen if there is unauthorized use of data. In this case, the data owner and the AI developer may face legal risk. So how can I resolve this situation? Data owner must, if he don't want that his dataset is used for AI training, he must exercise his faculty of opt-out. That could be a technical measure, for example, robot text, or a legal measure, for example, to insert in the terms and conditions a clause with the limitation of the use of data in AI training. On the other side, the AI system owner must pay very attention to the use of data and the clause inserts in the terms and conditions, because if the data owner limit this possibility, he can't use it for the AI training. So, at this point, are we safe? We have to ask ourselves, are we safe if we implement all these measures? The answer is no. No, because even if a dataset is comply with the EU regulation and then with the text and data mining, the single element of a dataset can be protected by copyright law. For example, text images can be protected by copyright law. So let's go to the second question of our discussion. Who is responsible for the use of data in training AI system? In this context, EU regulation creates a risk-based framework. This means that he want to identify the actors that are responsible for the use of data. In particular, the EU regulation identify providers of AI system that must ensure data quality, transparency, and documentation. Then deployers, so those who use data set, must pay very attention on the use of data. They must use it in a responsible way. And then he has to maintain human oversight. Then the general purpose of AI developers, this is a new category, and they must comply with the transparency and copyright law. What is the idea of the EU regulation? The idea of EU regulation is to distribute the responsibility along whole chain of value. all of the people has to be comply with the EU regulation and must pay attention in the use of it. So no one can say, it's not my problem, it's not my fault. All of us must verify if he can use a dataset, where they take it, and then if they can use it for the AI training. Let's go across the Atlantic. Across the Atlantic, there is no a similar of AI regulation. The courts decide on the base of fair use. Fair use, and that is a principle applied by the courts, based on 4 criteria. The first one is the use and the purpose of, for which the work was used, the nature of the data used, then the amount of the part of data, because if I use a small part of the data, it can be not considered infringement of the dataset, and then the effect in the potential market. This is a flexible way to decide on the dataset, because the infringement of the dataset, because there are no a simple clause, a provision from an act that can say if it's is it correct to use it or not, is it possible or not, but it's a different way. In Europe, last year we had the first case on the AI training. The first case where a court decided that the use of data in training AI system for scientific purposes is not an infringement of the dataset. In this case, the organization, Lion, was a non-profit organization, used construct a dataset, taking the images from the website, but it used it for the scientific purposes. So the court decided that it's not infringing the law. But let's go to our conclusion of discussion of today. It's very, very important to understand that the AI training is not a technical process, it's also a legal one. This is because when you use data as the fuel of the AI revolution, but you have to consider that data are owned by someone. So, in my opinion, the future of AI, it depends not only on algorithms, but also in trust. Trust that the data we are using are safe, are transparent, and taken legally from the dataset. So my advice as a lawyer is build compliance into your innovation, not after it. Thank you very much.
Thank you, Veronica. We have a minute for questions, if there are any. Yes, there is one on this side. The microphone is just arriving.
Okay. So I have one question in regards to data which is published on the internet. Let's assume that I'm a writer, for example. And as I understood, within the European Union, I can use terms and conditions on the website to say this should not be used for trading purposes, right? So,
yes.
And then it cannot be crawled and go into systems.
If you are creating, for example, a lesson for a student, you can take photos, for example, online, and construct slides for teaching your student. But if you are using it, for example, I'm thinking about a web agency that use data online and sold this service to other people. This is infringing. He is infringing the law because he can't use for trade for earn money. Okay. In a simple word.
Okay. So, and the second part is how I can defend against the U.S. companies.
Against U.S. company, and depend the jurisdiction in the case, because if you are in Europe, you can defend on the European law. If you are on, if the competition, the jurisdiction is of United States, you have to, the court decides on the principle of in United States.
Okay, thank you.
That's clear. So.